A very good afternoon to all my dearest student friends. Indeed, it gives me a great deal of pleasure in again coming back for the last deliberation, that is insolvency and bankruptcy. In this deliberation, I will touching upon what do you mean by insolvency. Obviously, we'll be talking of corporate insolvency legislative framework in India and prior to what was there 2016, and what is that unified insolvency and bankruptcy law, that means the insolvency and bankruptcy code 2016, and what are the four pillars of institutional infrastructure under IBC 2016. Apart from that, I will talk about the corporate insolvency resolution process, including your liquidation process under IBC 2016, and what are the consequences of individual insolvency, cross-border insolvency, and different leading cases. So it is expected that after hearing my deliberation, one should be able to understand the basics of insolvency law and its practices. One will be able to describe the legal and regulatory framework, the legal and regulatory system relating to distress or insolvency resolution in India prior to enactment of the IBC. Apart from that, also, one will be able to explain what are the essential ingredients, what are the essential segments of the corporate insolvency under the Insolvency and Bankruptcy Code 2016. And above all, one will be able to discuss about the different aspects relating to individual bankruptcy and liquidation of insolvent companies. So to start with, I'm going to give you a befitting introduction so far as insolvency and bankruptcy is concerned. So here, I'm going to explain the law and the mechanism related to your corporate insolvency resolution process of corporates in India. So here I start with describing the legal situation, describing the regulatory situation in place prior to your enacting of the Insolvency and Bankruptcy Code 2016. Further, I would like to examine the necessity, the need to adopt the Insolvency and Bankruptcy Code 2016. And hereafter, I will refer it to IBC or code. So I am going to discuss, to start with, what are the essential, what are the salient aspects of the code with the help of leading cases. So what type of regime? The regime is effective insolvency regime. The regime is efficient insolvency regime. So if I say an effective and efficient insolvency regime, then it should aim to achieve the key objectives which are very much identified in a very balanced manner. So it is to provide certainty in the market, that to promoting your economic stability, that to promoting your growth. In addition to that, it is to maximize the value of assets. Apart from that, we always try to strike a balance. It is the balance between your liquidation and reorganization. In addition to it, we always keen on how best we can ensure equitable treatment of similarity situated creditors. And nevertheless, it would be unfair if I don't say that our focus is to provide for timely, efficient, and that too impartial resolution of insolvency. So, student friends, you must have heard that I've been using the word insolvency many times. So, what does it mean? What do you mean by insolvency? How are you going to define insolvency? So, we have got United Nations Commission, and that too United Nations Commissions on International Trade Law. So, there is a legislative guide on insolvency law that is going to define insolvency is when a debtor is generally unable to pay its debts as they mature, and when its liabilities exceed and the and when I say exceed the value of its assets. So if I say in the context of UK Insolvency Act 1986, they try to define insolvency. Obviously, a company is insolvent. When do you say so? When it is unable to pay its debts. So the concept is very simple enough. But as we shall see, there is more than one test, maybe to it is a test of inability to pay debts, and its marginal cases that may be far from easy to determine whether the test is satisfied as in the relevant time also. So if we go for the Oxford Dictionary, it defines the word insolvent, that somebody not having enough money, as I told you, to pay debt, to pay the creditors. And it is all it is all relating to insolvent people or the state of being insolvent. So surprisingly, unlike the international laws, the code doesn't define insolvency, in fact, in implicit, or rather it would be proper to say in explicit terms. But however, the term default by the corporate debtors has been marked as the trigger for initiating the insolvency proceedings. So, bankruptcy law reform committee report explains the term financial failure. It is a kind of persistent mismatch between the payments by the enterprise and the receivables into the enterprise, even though you may say that the business model is generating revenues. Similarly, in case of business failures, which is in fact, you can say breakdown in the business model. It is the business model of the enterprise, and it is unable to generate sufficient revenues to meet its payments. So now going over to the corporate insolvency legislative framework in India prior to 2016. Obviously, in case of India, had a patchwork of insolvency courts and tribunals, and those tribunals, they are applying to different classes of stakeholders. They are applying to different classes of processes, and those processes, in fact, which resulted in parallel proceedings. And you have conflicts between two statutes, conflict between two uncertainties for the creditors over their recovery. So when there is a conflict, So the conflict and the multiple proceedings that are arising from the, you can say, multi-layered insolvency law framework, it all pointed towards a very, very strong necessity need for a unified bankruptcy code, which could be applied to all those aspects of a company in distress and for all its stakeholders. So you have complex web of laws, which is recent past, and that is all governed by your corporate bankruptcy and insolvency also. So if you look at the Companies Act 2013, CA 2013, obviously the Act contains certain provisions, and those provisions on collective insolvency resolution, and this is by way of restructuring, this is by way of rehabilitation, or this is by way of reorganization of entities registered under the Act. So we have adjudication authority. Adjudication authority is nobody but it is the National Company Law Tribunal. In short, we call it as NCLT, National Company Law Tribunal. So CA 2013 contains provisions for rescue. It contains provisions for rehabilitation of all registered entities which are there in chapter XIX and liquidation in chapter XX. So we have also Companies Act 1956, CA 1956. So here also you have legislation, and those legislation deals with winding of companies. And this is, however, no separate provision for your restructuring except through only merger and acquisition, and if you go for voluntary compromise. Because we have adjudication authority. Adjudication authority is the High Court of the respective state. In addition to that, also we have SIC, Industrial Companies Act 1985, SICA 1985. So this act deals with restructuring of distressed industrial firms, and under this act, the Board for Industrial and Financial Restructuring, so we in short call it as BIFR, assess the viability of the industrial company, and normally it refer an unviable company to the High Court for liquidation. So if you look at SICA 1985, it contains special provisions for timely detection, for the timely detection of any kind of situations which are unwarranted. And apart from that also, we always look for the sick industrial companies, how they can be revived. For then we should undertake some kind of preventive remedial measures in respect of such companies. In addition to this, also we have recovery of debt due to banks, recovery of debt due to Financial Institutions Act 1993. So this act gives bank and specified set of financial institutions greater power to recover some kind of collateral as default. So the law provides for the establishment of your Special Debt Recovery Tribunal, DRTS, for enforcement to enforce debt recovery by these institutions only. That is why the law also provides for the debt recovery appellate tribunals as the appellate forum. And above that, the securitization and your reconstruction of financial assets and enforcement of Security Interest Act 2002, because this act enables secured creditors to take possession of your collateral without requiring the involvement of court, without requiring the involvement of tribunal. In fact, the law provides for actions by secured creditors to take precedence over a reference by a debtor to BIFR, and DRT is also there, that is a forum or appeals against such recovery. So in this connection, it would be appropriate to mention certain issues, and those issues relating to various legislations dealing with corporate insolvency, dealing with corporate restructuring. So if we look at SICA, that is your Sikh Industrial Companies Act 1985, whose net worth has eroded by 100%, no doubt about it, and they are all identified as being in distress, and they are all reference to the BIFR, and thereafter BIFR must investigate the potential validity of the industrial company, and after doing it, then either recommend its rehabilitation scheme or recommending winding off before the High Court. So if you look at the issues with the legislations, the first issue which will arise, that is your delay. Under SICA provision, in fact, 5 to 7 years are required for reviving a company, out of which you may say around 3 to 4 years are required just to decide whether a company needs rehabilitation or company needs liquidations. Because delays further contribute to other issues such as the debtors using the delay to defer payments to the creditors, and because of the memorandum that is placed before the creditor enforcement, obviously the corporate assets being siphoned off during the long drawn process, and in fact managers coercing creditors into extending further finance or giving some kind of rebate, giving some kind of concession in existing debts. So it has been observed by the SICA is capable of achieving a swift liquidation only when creditors they rejected the possibility of revival. After this issue of delay, there is also improper identification of companies that can be restructured. So it would be worth mentioning that it has been repeatedly stated many times that BIFR has failed to satisfactorily identify companies which are capable of restructuring, which are sanctioned schemes altogether, which have severely hampered the creditors' interest, everything. So these could be different issues, and where if we look at SICA, doesn't assist the creditors, that you must take it granted, because in many of the cases where the creditors they seek liquidation, the cases have been sent back to again BIFR to conduct inquiry into rehabilitation. Similarly, your SORPAC, that is another act and which provides mechanism to the secured creditors to take possession of the property of the debtors without any kind of interventions, and the intervention by the court, intervention might be the tribunal. So finally you can go for an appeal, and this appeal against such possession made by or may be made to the DRT. Similarly, you have RDD BFI. This is one act focuses specially on the easing recovery for banks and other financial institutions, whether it is secured creditors or unsecured creditors. That is why the act additionally provided for your establishment of DRTs and DRTs. Now, coming to the Unified Insolvency and Bankruptcy Law, obviously the Insolvency and Bankruptcy Code 2016. As I told you a little while ago, host of legislation, host of form, combined with potentially conflicting issues, potentially uh, judi- jurisdictional issues, and in the that too to carry out in a more systematic way, and the delays and complexities in the uh, insolvency as well as bankruptcy process. And additionally, all these legislations have been identified as being inadequate in by themselves. So that is why your insolvency enacted, and that is why your when you are talking of this, the code aims to consolidate the laws relating to insolvency of companies or your limited, you can say, liability entities, including limited liability partnerships or other entities with limited companies. And we have unlimited liabilities, the partnership, other than the entities with limited liability. Because if we keep the unlimited liabilities, obviously it is the limited liability partnership, and in most of the cases other entity with limited liability. And if you are talking of unlimited liability partnership and individuals, those presently contained in a number of legislation into a single legislation. That is why such consolidation will provide a greater clarity in law, and it will facilitate the application of consistent, the coherent positions or the provisions has to be there to different stakeholders who are affected by the business failure, or who are affected by the company's inability to pay the debts. So here, an effective insolvency regime, when we are talking of it, is a critical component. It is a critical component of ease of doing business, that to a country like India. So the code, in fact, considered as the biggest economy to reform next only to GST. And the insolvency regime is always expected not only to the to facilitate the uh, an easy revival and rehabilitation process for companies, and that too in financial troubled times, but also to be very uh, effective in safeguarding the interest of the stakeholders, such as your creditors, your shareholders, and the government. It is also expected that it should stabilize the command dealing with some kind of financial stability, and better uh, you don't do that, but better environment has to be there for attracting investments, and besides mitigation of corporate failures. So if I look at the salient features of ABC 2016, I find that there is a very clear, um, coherent, and that too timely basis speedy process for early identification of financial distress, and the resolution of the company are limited liability and entities if the underlying business is found to be viable in any case. Apart from that, another feature would be two distinct processes for resolution of individual and fresh start and insolvency reconciliations. So you have also debt recovery tribunal and national company law board. These are all have been set up, but the fact remains that adjudicating authority and the deal with the cases relatively, I can give you some kind of suggestion that cases related to insolvency or the cases related to liquidations and bankruptcy process in respect of your individuals, in respect of your unlimited partnership firms, or you can ask them in respect to the companies and limited liabilities entities will always be there. So there is also another establishment of an insolvency and bankruptcy board of India to exercise regulatory oversight over insolvency professionals. And insolvency professionals would also handle the commercial aspect, and insolvency resolution process is very, very important, because insolvency professional agencies will drop professional standards, the code of ethics, and be first level your regulator for insolvency position, leading to development, and that to development of a competitive industry for such professionals. And information utilities, which is also essential, would collect, and that is going to be collected, and authentication has to be given. And finally, there will be dissemination. There will be dissemination of interest information, and that too to be used in insolvency, liquidation, and bankruptcy. Now, coming to the four pillars of institutional infrastructure under IBC 2016. There exist four pillars of institutional infrastructure which is created by IBC 2016. What are those pillars? The first pillar is your insolvency professionals and insolvency professional agencies. This is the first pillar of institutional infrastructure. It is a class of regulated persons, and you have insolvency processes, and they play a key role in the efficient working of the bankruptcy process, and they are all regulated by your insolvency professional agencies. Because we have been talking about insolvency, but an insolvency professional plays a central role in the effective and efficient implementation of an insolvency law, because you have to do it with certain power over the debtors. You have to do it with certain powers over their assets and duty. Your duty is to protect those assets and their value. So, as far as well as interest of creditors and employees are concerned, uh, they will better ensure that the law is applied effectively and impartially. So, your IP insolvency professionals may hold some of the role under this code, like you operate like a resolution professionals, and to solve the insolvency for a firm or the individuals. So another thing is that the bankruptcy trustee, he's an individual bankruptcy process, and if you have bankruptcy trustee, he's an individual bankruptcy process. If you have liquidator in a firm, so that there will be a liquidation process. Now question arises, who can be insolvency professionals under 2016? So regulation 5 of the insolvency and bankruptcy board, they involve professionals. Then in that case, the regulation 2016 provides certain qualifications, certain experiences altogether to become a insolvent uh, um, professionals. So subject to or other provisions of these regulations, as individuals shall be able to go for the regulations. So in this case, what is important that one has passed your national insolvency examinations, one has uh, passed the limit insolvency examination, and has fixed years of experience in management, and that too he received a bachelor's degree from the university established or any recognized by the university. So he has passed the limited insolvency examination and the 10 years of experience. So if you have got chartered accountant enrolled as a member of Institute of Chartered Accountant, that to India, a company secretary is when we are talking of has enrolled as a member of institutions, and the cost accountant enrolled the you can say as a member of the Institute of Cost Accountants of India. Now coming to the second pillar, that is your information utilities, because the second pillar of institutional infrastructure is the institutional information or information institutions. So there are service providers. What they do, they are all required to store facts about the tender and what would be the terms of lending in the electronic database, and this is all they intended, you can say, to eliminate delays and to dispute in both the cases about the facts when the default takes place. And any information utility is very much competent. And here they are very much contemplated as a registered service provider who shall be obliged of that you create financial information, you also store financial information in a universally acceptable forms. So you accept the electronic for submissions or the financial informations, and from there, under the obligation of you can say to submit financial information under this code in such a form and the manner as may be specified by legislation. So if you are accepting, obviously you accept in specified form the manner in which it is told, and the information submission of your industrial relation or the financial information that you are talking of, because we have got accept in specified form in a specified manner, electronic submission of financial information form that goes persons who intend to submit, then in that case, the accept and in respect to the form, in respect of the manner, electronic submission of financial information form, your persons he interact with, and in maybe who intend to submit such informations. So you have to meet such minimum service quality standards as may be specified by the regulations. So give the information received from various persons and authenticated by all your concerned parties before storing such informations. So you provide access to the financial informations stored by it, and that too to the person who intends to access such information and in such manner as may be specified with the manager. So I need to publish and in fact publish such voluminous statistical information as may be specified by regulations, and we have interoperationality with other information systems. And the third pillar is your adjudication. When I am talking of adjudication, obviously that is the third pillar, adjudication. And this is the third pillar of institutional infrastructure. They are the adjudication authorities. So we have got National Company Law Tribunal, NCLT in short. That is the forum where in fact bankruptcy, solvency of the corporate persons will be heard, and DRT is the form where individual solvencies will be heard. So the institutions, along with their applications, along with their appellate bodies like NCALT and the DRATs, will be adequately strengthened so as to achieve world-class functioning of the bankruptcy process. And apart from that, also we have got adjudication of your corporate Insolvency and Bankruptcy, that is National Company Law Tribunal. So adjudicating authority in relation to insolvency resolution and the liquidation of your corporate persons, including the corporate decisions are made where the guarantor thereof shall be your National Company Law Tribunal. Similarly, we have to also look at the territorial jurisdictions. NCLT will have territorial jurisdictions above the place where the organization office for the corporate person is located, and your NCLT before, which is a corporate insolvency, you can say corporate insolvency resolutions process or liquidation proceeding of your corporate debtor is a priming, and they will also have the jurisdiction in the manner of insolvency. So the aspect which we don't take into considerations, that is the jurisdiction has to be taken into consideration, the manner of the insolvency resolution or in the manner of its bankruptcy of a personal guarantor of such corporate debtors. So here, the guarantor of the corporate debtor pending in any court or the tribunal shall stand transferred to the NCLT dealing with insolvency resolution process or liquidation proceeding of such corporate debtors. So NCLT is very much vested with all the powers of the debt recovery tribunals and shall have the jurisdictions to entertain or to dispose of any application or any proceeding by a manager where the corporate debtors or corporate person will come into picture. So anyway, any claim made by the or any claim made against the corporate debtors and the corporate persons, obviously, in many cases, what we have seen that the claim made by or the against the corporate debtor or the corporate person, including the claim by the or the against of the subsidiary situated in India. So the question here, the question is question of priorities or any other question of law or facts, which is arising out of an person in relation to the insolvency resolution or your liquidation proceedings of the corporate debtors or the corporate persons under the code. So in this case, one thing which is more important that is to be seen, that is the civil code. Civil court not have the jurisdiction. So no civil court or authority has jurisdiction to entertain any suit or any proceedings in respect of any matter on which NCLT or National Company Law Appellate Tribunal has jurisdiction under this code. Similarly, no court, no tribunal, or no authority shall grant in injunction in respect of any kind of action taken or to be taken, that is in pursuance of any, I can say, power conferred on the NCLT or the National Company Law Appellate Tribunal under the code. So also we have adjudicator for insolvency resolution, we have adjudicator for bankruptcy of individual and partnership debt recovery tribunal. So in the process, the adjudicating authority is relating to your insolvency having, you can say, the firms, individual and the firms shall be the debt recovery tribunals having territorial jurisdictions over the place where the individual debtors actually and voluntarily they reside, carry on business, and personally, if I look at they work for gain or they work for entertainment, they can entertain people, and the application of general law or the general code regarding such persons. So the debt recovery tribunal, when we are talking of, shall have the jurisdiction to entertain um, or to dispose any suit or any sort of proceedings, rather I would say, either by or against of the individual debtor, or you can say that any claim made by or any claim made by the individual or against the individual debtor. So it is a question of priorities. So any question of priorities or any other question, whether it is a question of law or it is a question of facts. So that is the case why we emphasize more on the priority of any questions, whether it is a law of facts arising out of or in relation to your insolvency or in relation to your bankruptcy of the individual debtor or firm under this code. So, when we talk about Insolvency and Bankruptcy Board of India, which is the fourth pillar of institutional infrastructure, that is the regulator. So the Insolvency and the Bankruptcy Board of India, uh, hereafter we will calling is at IBPI and Bankruptcy Board of India. Henceforward, it is all relating to the board or with some kind of head office of the notion that is your national India. And we have got central government also, because the fourth pillar being the institutional infrastructure, which is the regulator. The insolvency board or the bankruptcy board, hereafter we'll call it as IBPI, or the head office in the national capital region and other offices of the places in India. So the central government has the power to designate uh, the financial sector regulator to perform the function till such time the board is constituted. So until the board is constituted or a financial sector regulator is designed or designated, obviously the section 195, or as the case may be, the powers and the functioning of the board of such designated financial stalwarts uh, will always be there. And board of such designated financial sector regulator, including its power to make regulation, I am of the opinion that they shall be exercised by the central government. And when you are talking of the central government, we have to look at the constitution of the board and how the members are selected. Obviously, the board shall consist of the following members to be appointed by the central government, who shall appoint them other than ex officio members. Because after obtaining the recommendation of a selection committee, the board consists of a chairperson and then three ex officio members of among the officers of the central government, not below the rank of your joint secretary equivalent. So this will be always there, because the very fact that one ex officio member uh, to be nominated by the Reserve Bank of India, and apart from that, five other members they have to be nominated by central government, of whom at least three shall be full-time directors. So we'll have to look at the tenure of the office bearers, that is given in section 189(4) of the IBC 2016. So the term and the term of office shall be the members shall be for a period of 5 years, or you may say until they same or they attain the age of 65. So whichever is, I would say, uh, earlier, because they are eligible. They are all eligible for reappointment as well. Because if you look at the board, what could be the objectives of the board? The objective of the board is to utilize all legislative, all executive, all quasi-judicial function so as to achieve your self uh, functioning bankruptcy process in India. So this would include features like high recovery rate in the NPV sense, your low delays for the, I would say, from start to end, beginning to end, low delays from start to end, sound coverage of the widest possible class of claims. That means your bank, loan, corporate bonds, like that. You have got a perception gradually, normally in the mind of the person, that too in the economy, that India has a swift and a competent bankruptcy process. So that is why when we talk about insolvency resolution process, obviously we always look for corporate insolvency resolution process. So the corporate insolvency resolution process may be initiated under the Chapter 2 of the Code in respect of the corporate debtors, and it has got committed. It is all committed at default, because the trigger point of initiating the corporate strategy resolution is the occurrence of your default, and whenever there's a default would have occurred when the debtor fails to pay, as I told you earlier, the whole or part or in installments, and the manner of the debt is also decided. Liability and the obligation in respect of claim, which is also due, very much due from any person, and includes your financial um, viability. And finally, what you try to see, that is it something for which remedy for breach of contract under any law for the timing in force, or if such breach gives rise to right to payment, obviously whether or not such right is reduced to judgment or fixed, matured, unmatured, in everything. So the fact remains that nobody comes forward for this type of thing. So who can initiate the process then? The process for initiating corporate insolvency resolution may be initiated by a financial creditor, may be initiated by the operational creditor, may be initiated by your corporate debtor, because there has to have the commencement by the financial creditors. And whenever we have financial creditors, so there is an application to be made by the financial creditors, and the financial creditor may initiate the process either by itself or jointly with other financial creditor by filing an application before NCLT. And if a default has occurred in respect of or any kind of financial debt, not only to applicant financial creditor, but to any other financial creditors of the corporate debtor even. So the financial creditor is a person to whom, in fact, financial debt is owed, and includes a person to whom such type of debt has been legally assigned, or it might have been transferred to. So you have to ascertain the existence of debt, default by the NCLT, and there will be date of commencement. The corporate insolvency resolution process will shall commence on the date of admission of the application of the financial creditor by the NCLT. So there will be order of admission of such application, and that shall be communicated by the NCLT to the applicant. And apart from that, the corporate debtors or of rejection to the financial creditor, if that is to be made, that is to be made within 7 days. So there will be declaration of moratorium, and the public announcement will also follow. Because with regard to the creditors, one of the fundamental principles of insolvency law is that insolvency proceedings, whenever we are going for, they are all collective proceedings which require the interest. And when I'm talking of the interest of all creditors to be protected against the individual actions by one of them. And many insolvency laws, they include the mechanism to protect the value of the insolvency estate. Not only it prevents creditors from commencing actions to enforce their rights, but through legal remedies, doing some or all of the period of the liquidation or reorganization proceedings. But sometimes also it suspends the actions all which are already underway against the debtor. So such type of mechanisms when we are looking for is variously termed as moratorium, uh, variously termed as your suspension or stay, depending upon the effect of the mechanisms. So the code, in fact, provides for the moratorium from creditors against, obviously, action against the corporate debtors. So when the NCLT passes an order of admission of an application for commencement of corporate resolution process, obviously NCLT shall by an order grant a moratorium mentioned in section 14. And NCLT also will appoint an interim resolution professionals in the manner as laid down in section 16 of the code. And there will be a cause a public announcement of the initiation of the corporate insolvency resolution process, and call for the submission of the claims immediately after the appointment of the interim resolution professionals. Because whenever we are talking of moratorium, obviously it is order to declare moratorium, and the order to declare moratorium prohibits institutions of suits or continuation of pending suits or your proceedings against the corporate debtors, including some kind of execution of any judgment, decree, or other any in any court of law, tribunal or arbitration panel or other authority, or you may say transferring, encumbering, alienating, or disposing by the corporate debtors any of its assets or any legal rights or beneficial interest therein. So the order to declare moratorium prohibits all these things apart from the recovery of any property by an owner or the lessor, uh, where such type of property is occupied by, or those property they are in the possession of the corporate debtor. But one thing, there is exclusion from moratorium. The order of moratorium should not affect, in fact, the supply of essential goods, should not affect the supply of essential services of the corporate debtors, and which shall not be terminated or which shall not be, in my opinion, suspended or you may say interrupted during moratorium period. This is quite important, no doubt about it, to explore resolution of the corporate debtor as a going concern. Because one has to conduct the corporate resolution process by your resolution professionals. So after that, there will be resolution plan, and that will follow the approval of resolution plan by the creditors. And finally, the NCLT will provide approval plan, and there will be rejection of resolution plan if the NCLT is not at all satisfied that the resolution plan that you are talking of, the plan itself doesn't conform to the requirements of the subsection 2 of section 30. Then in that case, it may by an order reject your resolution plan. And finally, there is also provision for punishment, and there is punishment for contravention of resolution plan. Here, the time is essence, because time limit for completion of insolvency resolution process has to be seen, because we are talking of corporate insolvency resolution process, and it provided in chapter 3 must be completed within the period. What is the period? Period is the 180 days from the date of admission of the application to initiate such type of process. And the period, that is 180 days, can be extended by NCLT up to maximum period of 90 days. Therefore, The if we look at the total period of for the resolution of corporate insolvency, including the extended period, can be can go up to maximum 270 days. So there is also provision for appeal before the National Company Law Appellate Tribunal, because an appeal to be made by a person, provided the person is affected, provided the person is aggrieved. And how did it happen? Aggrieved by an order approving the resolution plan by the NCLT. So the person may be that appeal may be filed before the National Company Law Appellate Tribunal, and henceforward we call it as NCLAT on the basis of certain grounds, like ground could be approved resolution plan is in contravention of the provision of any law for the time being which is in force. Ground could be there has been material irregularity in exercise of the power by the resolution professionals during the corporate insolvency resolution period, or if it is a debt owed to operational creditors of the corporate debtors have not been provided for in the resolution plan or in a manner it is specified by the board, because the resolution plan does not comply with any other criteria specified by the board. So if such appeal shall be filed within 30 days, then in that case NCLAT may allow an appeal to be filed after the expiry of the said period of 30 days. If it is at all satisfied and that there is sufficient cause also there for not filing the appeal, but such period shall not exceed however 15 days. Then if you are not happy, then you can make an appeal before the Supreme Court of India, because there is a fast track corporate insolvency resolution process, and you will go for the liquidation process because there is commencement, because liquidation order under this act is passed by the corporate insolvency resolution, and no resolution plan can be passed within the time period or the resolution plan passed is not complied with in any case with the liquidation. That is why we look for the grounds which are dealt. So the grounds for passing over the liquidation can be that if the under certain circumstances, provided if before the expiry of the insolvency resolution process period, a resolution plan is not received for approval by NCLT, or if it rejects at all the resolution plan for the non-compliance of the requirements which are specified. So if the corporate debtors also they do contravene the resolution plan approved by the NCLT, any person whose interests are prejudiciary, you can say, affected by the such contravention, they can also file the liquidation applications. So similarly, one can go for individually insolvency, because the Insolvency and the Bankruptcy Code 2016 in its part 3 provides for insolvency resolution and bankruptcy for individual and your partnership firms. So with this, we come to an end of today's session. Thank you very much. Have a nice time. Good day.